Court is now in session.
Please be seated. Good morning.
Good morning, Your Honor.
We're here in our case 1 CV22-0735, Trailhead versus the City of Phoenix. Each side will have 20 minutes to present their argument. Appellant, you may save as much time as you want for rebuttal. But keeping track of that is up to you, as well as the clock at the podium so that you can keep track of that. We are recording the argument both in audio and video. So when it's your turn to speak, please identify yourself so that we can keep track of who's who and who's speaking. The argument will show up on YouTube in a couple of days, so you can watch yourself and see how well you think you did. We've read the briefs, we've conferenced the case, so we're familiar with the facts and the law. So when you begin your argument, just start right out with what you'd like to talk with us about. Counsel, you may begin.
Thank you, Your Honor. Greg McGill, on behalf of the plaintiff below, Trailhead Restriction LLC, which is the appellant here today, seeking a reversal of a summary judgment that was entered by the trial court on the core issue, which was an issue of intent concerning an exchange of land in a concurrent escrow transaction that did not have an exchange contract.
Now, how long ago was the property
This was in 1978, but the trail that went into the hillside, the subject hillside that went into the South Mountain Preserve, and that's an important word, preserve, because in that preserve it's intended to be preserved. The trails that went in by the city went in late 2019, hence the action in 2020. We filed within 9 months of the harm, the alleged harm, or the trails going in. For 42 years, there was no development on the hillside. Hence, my client, which was the assignor, Barbara Nearson, who's here today, she's in the wheelchair there. She's the only party from 1978 that's still alive, ironically, and she's with Gordon Dicey, who's the owner of the sliver that the trial court, the 0.28 acre sliver that's part of Exhibit C that the trial court held as a matter of law, was the only piece in the trade that was restricted, the piece from the city to Nearson assigned to Trailhead. Gordon Dicey's here today. He's the only other living person. So the two parties that are here today, ironically, submitted declarations or affidavits regarding what the intent of the exchange were. There were no opposing affidavits or documents from the other side.
Counsel, you said that the harm occurred when the construction began in 2019.
Yes, sir.
Didn't the harm occur when a deed was recorded that didn't include what you claim it should have included?
No, there was no harm because you need damages. The harm, there's no damages if the city, basically followed for 42 years, over 4 decades, the intent of the parties, which was to keep the hillside pristine in the preserve and not develop it. So until there's actual injury or harm under the Gus Rosenfeld case and the Walk v. Ring appellate decisions, until there's a cognizable injury or harm which came from the development of the hillside that had not been developed for over 4 decades, there's no real cause of action. You wouldn't march into court when, it'd be a difficult complaint to march into court when the hillside is still preserved, and then file some claim for a declaratory judgment because you think a legal description or restrictive language may not be in the document.
People do sue to reform deeds. They do bring those claims.
Yes, they do, but that's when they know they have a cognizable claim and they have either actual, they have actual notice of a claim. If the problem rests in a legal description and there's no overt action that harms the other party, they wouldn't have any reason to.
So your clients will just realize, oh, this language isn't in the deed, and we hope nobody ever acts on the omission in the deed.
Okay, well, Your Honor, the answer is it's very straightforward. This was an exchange where Nearson was conveying 6 acres of hillside property in the preserve that was intended to be restricted from development and receiving about 1/4 of an acre sliver piece. Now the city managed to include the restrictive language in the deed that went to Nearson, the 1/4 acre, but Nearson's affidavit and Gordon Dicey actually submitted a declaration. The intent was that the 6 acres that she conveyed, the hillside, was intended to be, similarly restricted, but wasn't. So it's a case of mistake. It's a simple case of mistake.
I recognize there are problems, or at least discussions to be had about extrinsic evidence and parole evidence, but what contemporaneous evidence is there of that intent? Is there any evidence that we have available to us in the record that shows that at the time of this conveyance, that was the parties' mutual intent?
Yes, there is.
And what is that?
Okay, the evidence in the record is as follows. Number one, Judge Sinclair, it's on page 2 of her summary judgment ruling at the bottom. She says the 2 escrows in the exchange are linked together, and it's escrow 50 and 51. 50 is the 1/4 acre. 51 is the 6 acre hillside piece. The escrow instructions in 51 notes that it is subject to deed restrictions per attached supplemental escrow instructions. She held that this connects the 2 escrows with the supplemental escrow instructions. So to answer your question, so then you go to the escrow instructions. Again, there was no exchange contract to tell the trial court what the intent of the parties was. But when you go to the escrow instructions, and here's it in contract interpretation, where Arizona follows the Corbin rule on contracts, there's 2 elements. One is whether when the court looks at the words or the terms on the document, whether the language is facially ambiguous or not. That's one determination. The other determination is, and the appellate decisions right up to the Arizona Supreme Court in the Burkons versus Tycourt title case and Taylor versus State Farm, those are Supreme Court decisions. They say there's another analysis. You don't just look at the words. You look at the circumstances. But to answer Your Honor's question, when you go to the escrow instruction, here's the language. It says, the 51 escrow is subject, this escrow is subject to the 50 escrow. Subject to. What does that mean? Judge Sinclair never addressed that. It's subject to the other trade escrow, 50. That's the 1/4 acre parcel. And then it goes on to say, this escrow is also subject to deed restrictions per attached supplemental escrow instructions. What does that mean, subject to? What does subject to mean? Meaning that the 51 escrow, which is the 6 acres that Nearson conveyed to the city, the hillside, that she intended to be restricted, okay, that escrow, which ended up not containing the restrictive language in the deed, that escrow is subject to the 50 escrow, which is the sliver she was receiving. So what does subject to mean?
There's a third parcel here, though. Nearson received from the city 4.4 acres, right? This what you're referring to as the sliver came from a third parcel.
That's true, Your Honor. You're correct.
So the transfer between Nearson and the city, 6 acres to the city, 4.4 to Narrison. Neither of those deeds had a development restriction, correct?
That's correct, Your Honor. I believe that's correct. Now, the sliver is the one I keep talking about because that's the one that's Exhibit C that's in the supplemental escrow instructions. But to just address the subject to, what does subject to mean? Does that mean that the 51 escrow is just the 6 acres, and I keep talking about the sliver because that's the Exhibit C. The Exhibit C legal description turned out to be the sliver that went from that Narrison got and then conveyed to Gordon Dicey. That's the sliver that the judge ruled summarily as a matter of law. But the subject to, when you go to the definition of subject...
Just a quick aside, did all of that go to Mr. Dicey, or was it divided up among the different
There were three.
subdivisions?
The three members of the Trailhead LLC, they each got a parcel, and Dicey got the sliver, which turned out to be the Exhibit C.
So all of what you're calling the sliver went to Mr. Dicey? It wasn't divided up among the three
There were three separate parcels that totaled over 4 acres, as you said. You're correct on that, Your Honor. And then one went to Dicey, and that's the sliver that's Exhibit C. Yes, and there were two other owners, which are the other two members of the Trailhead LLC, Your Honor. You're correct, 100%.
And so they did not receive any part of this Christensen property?
I'm not sure about. But to address this language, so 51 is subject to the supplemental escrow instructions. So one issue is what is subject to. The court didn't address that. What does that mean? Does that mean it's tied to the other escrow? They're concurrent escrows. The judge held that they're linked together. They're connected. Does that mean it's tied to? It doesn't mean it's separate from. It's subject to the other one. So that's a facial ambiguity, to go back to Your Honor, Judge Perkins. So that's a facial ambiguity. Then when you go to the supplemental escrow instructions, and this is very important, when you go to the supplemental escrow instructions, it says the closing of this escrow, that's 51, that's the deed of the 6 acres from Narrison to the city, is subject to the seller placing deed restrictions on the property on or before this escrow closes, as described in Exhibit C, as described in. The ambiguity, facial ambiguity there is, as described in, meaning in Exhibit C, it's a legal description. So legal description, as described in, those are similar terms, so that the 51 escrow is subject to the restrictive language in the supplemental escrow instructions as described in Exhibit C. So as described in could mean Exhibit C has a legal description that's going to have restrictive language attached to that, which turns out to be the sliver. And the intent was, since it's concurrent escrows and an exchange agreement, that was intended, that these deed restriction language is also intended to be in the 6 acres.
I understand this is factually contrary to the argument, but if the parties wanted to put a deed restriction only on one part of the properties exchanged, not on everything as you're suggesting, wouldn't they have written the documents the way that they did?
Well, let me address it this way. The answer is, you're right, that's not what happened, but let me address your hypothetical, Your Honor. The answer is no, for one simple reason. Narrison was a real estate investor developer. She acquired this whole piece, and she was subdividing the property and then selling it off. It doesn't make there's no common sense or any business or reasonable purpose for her to convey 6 acres of a hillside property, the hillside which preserves the value of the underlying properties, for her to convey that to municipality without restrictions, meaning that development can go in that would diminish the value of the property she receives in the transaction. It defies common sense. It defies business logic, and the case that's on point is the Burkons versus Tyco title case. It's the Arizona Supreme Court, and they go through the same analytical construct as this case. It's virtually identical, and the Arizona Supreme Court in Burkons versus Tyco title, 168 Arizona 345, held that part of the analysis under the Corbin view of contracts is that the trial courts are cautioned, and this is also in the Taylor versus State Farm case, which is a celebrated contract interpretation case. They both hold that the construct on contract interpretation is that you got to look at the words in the contract and the surrounding circumstances, and the trial courts are cautioned against the temptation to just hold that words in a contract when the circumstances and the common sense underlying the transaction undermine the court's conclusion. That's what the court says.
But if the parties wanted, whether in today's view that makes business sense or not, if the parties had intended for the restriction to only apply to the sliver and not the other part, they would have written it the very way that they wrote it.
Well, Your Honor, except that there's two answers to that. We don't have to guess about what they intended because Barbara Nearson submitted an affidavit and a declaration, and the trial court rejected it. She rejected her declaration on her intent. So we don't have to get into a hypothetical. In this case, she submitted an affidavit, a notarized statement, which was turned into a declaration, and she expressed her intent that it was her intent all along to restrict the hillside piece that she was conveying to the city. Otherwise, it would undermine the value of the property that she's receiving. She told the court that, and the court ignored it. And I want to reserve the rest of the time I have for rebuttal, if I could.
Thank you, counsel.
Thank
We
you.
appreciate that. Counsel?
Good morning, Your Honors. I'm Darrell Manhart, representing the City of Phoenix. Seated at council table is Nathaniel Rose, who's counsel for lawyer's title, is available here too if you have any questions for them. The answer briefs of the city and lawyer's title address the contract documents and demonstrate that they're consistent with the deeds and all signed over 45 years ago. There's nothing inherently ambiguous or incomplete in those documents, and so there's no need to review any extrinsic evidence. There's nothing but the recent declaration of Ms. Narrison that contradicts those documents, and that's the basis of the complaint by Trailhead. A response to appellate's argument can be summarized as two things. One, the 2019 Narrison Declaration does not satisfy Trailhead's burden to prove the actual agreement was different from what the 1977 documents show. And two, any such claim should have been brought over 40 years ago. I don't have anything to add to the briefs except to reiterate the request that the judgment be affirmed and appellees be awarded their cost fees and a damage sanction. A lot of what Mr.
What's your
McGill said
response to
today.
Mr. McGill's argument that there was no harm until the city began construction in 2019?
Well, Your Honor, the argument that there's no harm depends upon you first accepting that the contract was actually what Ms. Narrison says, and that the restriction was supposed to be on all of the 6.13 acres that went to the city. But that's not what the documents say. And as I think it was your question that pointed out, or maybe someone else on the panel, the deeds say something else, and there's nothing that prevented them from seeing that the deeds did not put a restriction on the property that went to the city and asking for that to be reformed 40 years earlier. So there's no damage claim unless the contract and the deeds are first reformed. So waiting just means they ignored the fact that the deeds don't say what Ms. Narrison now says they were supposed to say. But I can walk you through the escrow contract too and show that that's the simplest way to look at this, is the escrow that ends in 051 is the escrow for the transfer from the Narrisons to the city. That escrow contract says that the land to be conveyed is described on Exhibit A, map is on Exhibit B. If you go to Exhibit A, there's a Part 1 and a Part 2 descriptions. At the top of that page, the title page, it says something like land to be exchanged and has a Part 1 and a Part 2. The map that's Exhibit B shows a Part 1 and a Part 2, and they're shaded, and you can see that the bigger part, I forget which it's Part 1 or Part 2, but the bigger part that's shaded is right below an area that's not shaded that says restricted area. So the restricted area is not the part that's shaded. You go back to the escrow contract, the language that Mr. McGill refers to, lower left-hand corner of that escrow agreement says that it's subject to. One of the things it says concurrent closing of the escrow in 050. I don't find there any mystery that Mr. McGill says, that it just means they have to close at the same time. And then below that it says that it's subject to the supplemental escrow instructions, the deed restriction and the supplemental escrow instructions. We have the supplemental escrow instructions. They have the same escrow number on them, so you know it's part of that escrow contract. And it says the seller, which was the Narrasons in that escrow, are supposed to impose a restriction on land described on Exhibit C. Exhibit C is attached to that. Exhibit C at the top says land to be restricted. And it has a different legal description than what's on Exhibit A. So I think relevant to one of the questions that was asked of Mr. McGill is, why wouldn't the contract have been written differently if that's what's intended? That's my point too, is if it was supposed to be on the land that was being conveyed to the city, that deed restriction language would have said it's on Exhibit A. It doesn't. It says it's on Exhibit C. There was no need to have another restriction.
Counsel,
Yes.
your colleague argues that it makes no business sense to limit the restriction to the sliver and not all the property. What's your response to that?
Well, Your Honor, I would liken it, maybe it's a poor analogy, to like constitutional analysis where the lowest level is rational basis, and you only have to show that there's some rational explanation for the law that's subject here. So on that side, he's arguing that it doesn't make business sense based upon the intent Ms. Narrison now wants to say in 2019. But there's a common sense or business sense to the way it is written too, which is that here the city is the party with leverage. You notice that the trade is 4.4 acres from the city to the Narrisons, in exchange for which they get 6.13 acres and $5,500. The statement in Ms. Narrison's affidavit says they needed to get this land to create buildable lots. So they have a piece of land that maybe it could have been built with one home on it, but they have land they can't build on unless they get more buildable area. So they trade more land and get less land, but it's land in an area that allows them to build. Also, the city already is bringing this into the preserve, which already has restrictions for public recreational use. They don't need to have any restriction on that land. The common sense or business sense here is part of the land that the city's not trading to the Narrisons, but they're getting from somebody else, is that sliver. And by the way, the sliver isn't just on Mr. Dice land. It was on all of parcels A, B, and C. Most of it's on his part, but it's the eastern edge of all three of the resulting developable lots. So the city is the one that wants to restrict that hillside property on the person that's developing it, who admits that they want that land to be developed. So the city's saying you can have this land to create developable lots, but here's a portion of it that you can have to make your lot sizes come out right for building permit purposes, but you're not going to be able to build on that part. All of that makes perfect sense. And all of that is, I submit, all you need to show that the contract documents make sense. You can't argue, well, there's another way they make sense, and therefore it should be construed differently. But again, back to my point on the escrow contracts, they completely make sense with the way they're written. Exhibit A property being conveyed with no restriction. A restriction specifically said to be on Exhibit C property, which is different property. The deeds that result from that, all completely consistent. The deed to the city, signed by Ms. Narrison and her husband, doesn't have any restriction on it. They also signed as grantees, receiving the property from the Christensens, which did have a restriction. There's no way that they can legitimately say today that when they signed all those deeds, which are all recorded the same day, so I'm going to presume they were signed in close proximity, that there's a mistake. If there was one, it's one that they had a duty to bring a cause of action on a lot earlier, which is the problem. Another problem with their case is even if you accepted that the intent should have been different and these documents should be reformed, they can't get past the statute of limitations on that. The statute of limitations on every possible claim they've asserted ran 40 years ago. So I'm happy to entertain any further questions if there are any, but our position is this is a meritless claim. It should be affirmed. And I don't know if Mr. Rose has anything to add for lawyer's title. I'll sit down so you can have the rest of the time. Thank you.
Morning, Your Honors. My clients join in what Mr. Manhart said, and the positions are aligned on, all the significant issues. One thing, and Mr. Manhart kind of explained it now, you have to, with the subject to language, the property that the city wanted restricted to create this buffer between the property they were getting as part of the park and the property they were giving up to Ms. Nearson and her husband to be developed was coming from a third party. So what the city, the subject to is, we're not going to do this land swap unless you agree to restrict the property you're getting from a third party, because it's not a party to this escrow, that party's not subject to these escrow instructions, so you as a party to this escrow have a duty to make sure that the property you're receiving from the third party is restricted in this way to create a little sliver of buffer between what's going to be the park and the property you're getting to develop. Makes perfect sense. A 42-year after the fact parole evidence declaration of some alleged uncommunicated subjective intent cannot be used to create ambiguity. You only go to
Counsel,
court.
the plaintiff also asserts a claim against your client for breach of fiduciary duty. You should have caught this sooner, basically. What's your response to the argument that that cause of action doesn't accrue until 2019 when the city started developing the property?
Well, first you got to look at Berkins, which defines the duties of an escrow agent. And there's two duties: strictly comply with the escrow instructions, notify one party if you have red flags of fraud committed by the other party to the other. Because, as I explained in the briefs, there's not a general fiduciary duty because there's duties owed to both. So there's no way you could be a general fiduciary one because Berkins says you owe duties to both. So those are the limited duties. And one, there's no escrow instruction in evidence saying anything is to be restricted other than the sliver. So my client complied with this escrow instruction that was given to it. So there is no breach.
So all your client knows about the intent of the parties is what's in the escrow instructions.
Exactly. This alleged subjective uncommunicated intent is not even valid parole evidence, even if you could go to parole evidence. Because nowhere in that declaration to say, I told lawyer's title, I told the city the property I was giving them also needed to be restricted, and they agreed. That's completely absent from the declaration.
When do you think the breach of fiduciary duty claim accrued?
Well, first, not to get too deep in the woods on breach of fiduciary duty, for the reasons I explained, there is no breach of fiduciary duty claim against an escrow agent because there's no special relationship. And Berkins even held that in Berkins, they were looking at a breach of covenant of good faith and fair dealing claim, and they held in the facts of that case, they weren't going to allow tort damages. So if it was a fiduciary relationship, which it can't be because they owe duties to both parties, so that I think is significant. But to get to this duty of harm, he's trying to strap on tort duties of harm to breach of contract claims. And this idea of needing to have knowledge of the harm arises, at a different time than the act that caused the harm in, say, like medical malpractice cases where, the sponge gets left inside the stomach and the patient doesn't even know the sponge got left in until they start suffering harm, some physical injury from it. Or I think some of the cases are sexual abuse cases where there's repressed memories. The statute doesn't start running until the memories are no longer repressed. In the breach of contract cases, the courts have held that the accrual date is the date of the breach. And especially when the breach is easily determined, as it is here. When she signed the deed, she knew it didn't have the restrictions that was in the deed she was receiving. So if that was really the intent, then the accrual is the date of the breach, the alleged breach of giving her a deed to sign that didn't have the instructions.
What damage has she suffered until something is built on the property?
Well, it's that the contract was breached. I mean, that's the case law on breach of contract. The damage is the breach. This idea of having to have some monetary damage that you're aware of isn't in the breach of contract statute limit cases.
And the remedy would be to fix the deed.
Yes, correct. It would be to sue, to reform the deed, to conform with the intent, but here, and this is part of the statute of limitations too, because if it's not statute of limitations, I don't know if I've ever, other than putting latches in an affirmative defense, I've ever argued latches, and if there's ever a case for latches, this is it. We got 42 years, all the witnesses are dead, we have only a few documents that are documents that the plaintiff happened to hold on to. So, I think that figures into the statute of limitations analysis as well. Unless, does the court have any more questions for me?
Thank you, counsel.
Thank you.
Rebuttal?
Yes. I think I have about 6 precious minutes left, so if I could try to roll through this fast, Your Honor. Thank you. To go back to Judge Perkins' question, which I thought all the questions were spot on. Judge Perkins, I'd like to go back to your question. If you go to these supplemental escrow instructions, a lot of this argument, what's ironic is defense counsel keeps saying, well, everybody, I think what they're distilling down, they're saying everybody kind of knew what was going on here, and she must have known that the 6 acres hillside that she's conveying to the city, she must have known that that was not to be restricted, and then they, on the same token, they say, well, but she should have realized that if it was to be restricted, she should have realized it then, even though Exhibit C, the escrows refer to Exhibit C, which is a legal description in an exchange escrow. Okay, by definition, she's saying, her affidavit said it was a mistake. There was no harm till 2019 when the development went in. So that's when her cognizable claim occurred. It's a mistake. She's not going to know about it if it's buried in a legal description, and it's a mistake. And there's no development for 42 years. The development goes in. Then she files a 9 months.
She signed the documents, right?
Okay,
So
she signed the
she could
documents.
know what
So let me
say.
go to the supplemental escrow instruction. The other thing that defense counsel leave out in the supplemental escrow instruction, and the trial court missed this too. It says the restrictions may not be removed without the consent of all the adjoining property owners. That's in the supplemental escrow instruction. That was the focus of the trial court. But, so you have to get a consent of all the adjoining property owners to remove or adjust any of the restrictions. You have to get the consent of all the adjoining property owners. The sliver doesn't touch all the properties. The hillside does. The hillside that we're talking about today, the 6 acres that she conveyed to the city, is the only property that touches all the owners. So, in terms of contract interpretation, the trial court is not to render an interpretation as a matter of law that renders any of the language in the contract superfluous or meaningless. That violates a fundamental contract interpretation principle. And Burkons goes through this. Burkons versus Tyco Title, which is an Arizona Supreme Court case. The restrictions may not be removed. This is in the supplemental escrow instruction. Without the consent of all adjoining property owners, adjoining, only the 6 acres that went to the city that she said in an affidavit was intended to be restricted. That's the only piece that has adjoining property owners, because the sliver doesn't touch all the adjoining property owners. And they don't even talk about it. The trial court didn't talk about it. Defense counsel today's not talking about it. And they got a summary judgment in this case without addressing that key point. The other points that I want to make is the escrow instruction, not the supplemental, but the escrow instruction And lawyer's title, Stillwell, their person in a deposition, I asked her, in the escrow instructions below the city signatures, and they signed it, so there's no statute of frauds problem, it says that the 51 escrow is parcel 13 South Mountain Preserved. That's underneath the signatures. Stillwell, on behalf of the escrow company, testified that parcel 13 included all the properties that we're talking about, not just the sliver. That's another thing to address Judge Perkins' question of what facially appears on the documents that would cause two reasonable interpretations, which is another definition of an ambiguity. You can have an ambiguity facially, or the circumstances can suggest two differing interpretations, which is also an ambiguity. The other point that I want to make is that the language says one escrow is subject to the other. And the case on subject to is Woodworth versus Woodworth, 202 Arizona 179. It's an Arizona Court of Appeals decision, it's published, and it says that subject to is defined, and it cites dictionary definitions of what subject to means. And it was a child support case, and the language there said a parent who does not comply with the notification requirements of this subsection is subject to court sanction. So the issue is, what does subject to mean? And the court says the words subject to must be construed in their natural, plain, and ordinary significance. The words subject to are defined by lexicographers as meaning liable or accountable for. And so it's a time concept. One escrow is subject to the other escrow. And in the escrow instructions, it says 51 is subject to 50. It says it 2 or 3 times. And it says you have to get the approval of all the adjoining landowners in the language. The other point is that the Burkons versus Tycor title case, they went on for a page or two talking about the business, there was no business rationale for her. There might have been a business rationale for the city to restrict the piece that they conveyed, but there was no business rationale for Nearson to convey 6 acres of hillside property and not restrict it because it's going to damage the value of her property. There was no business rationale for her.
Thank you.
That's the point. Thank you.
Your time is up. We appreciate your arguments today. We're going to take this matter under advisement and will issue a decision in due course. We stand adjourned. Thank you.